Hello everyone, good afternoon and welcome to this meeting of the North Sydney Local Planning Panel. Can you all hear me?
Yes.
No, you're all on mute. Just put thumbs up if you can hear me. Looks like it's okay. Sounds like it's great. I'd like to begin by acknowledging the Camaragal speaking people, traditional owners and custodians of the land on which we meet, and pay respect to Aboriginal people past and present in the ancient culture of which they are part. My name's Jason Perica. I'm chairing today's panel meeting. I'm an alternate chair. Jen Morell's the permanent chair and part of the panel, but I'm chairing today. Just as brief background, I've had over 30 years experience in both local, state and private practice, including at senior levels. But I might ask the other panel members to do an introduction of themselves and then I'll go through the running order.
Hi, Jan Morell. I'm an expert member on the panel today. I chair a number of panels in the Sydney region, as well as sitting as an expert, and also sit on the Sydney East State panel. I've got over 40 years experience and I've been on this panel since its inception. Thank you.
Okay, I'm Caroline Pidcock. I'm an architect in Sydney and member of this panel, Liverpool Design Excellence Panel, Sydney Olympic Park Design Excellence Panel, and Northern Beaches Sustainability and Design Panel. Thank you.
Hello, my name is Virginia Waller. I'm a registered architect in New South Wales. I've been and practice as architecture in private practice. I've been on this panel, the North Sydney Local Planning Panel, since its inception, 2013. I'm also on the Sydney North panel.
Okay, so thanks for that. It's a bit hard to see on the screen, but the four of the panel are up the end of the table. We also have some council staff, including Stephen Beattie, here to assist us and also help if questions arise during the meeting. The panel's to consider the determination of 3 development applications and 2 modification applications as published in the agenda papers. The order of consideration will be as published, being for the sites known as 12 Premier Street, Neutral Bay, 173 West Street, Crow's Nest, 10 Oak Street, North Sydney, 49 Carter Street, Camaray, and 61 Lavender Street, Milsons Point. There are no apologies. I'll ask for any declarations of interest. I don't have any. No
declarations of interest?
No, for me.
And my second cousin, who I don't see a lot of, made a submission for 179 West Street, so I will sit out just in case there was any perceived sense of conflict.
Thanks for that. So it's not a direct conflict, but a reasonably perceived one. So Caroline Pidcock won't take part in that item, but we'll still have 3, which is a quorum, so that will continue. What I might do next is just clarify who I've got down as the speakers list. So for Premier Street, I've got the applicant's representative being Stuart Bryson. For 173 West Street, I've got the applicant's representative Stephen Fale and Bruce Cuttance. For Oak Street, I have Linda Hyler speaking against the proposal. And for the applicant, I understand Simon Rosewell, Louisa Alessi and Cameron Allen Gillies. For 49 Carter Street, there's no registered speakers, and 61 Lavender Street have the applicant's representatives being Sandra Robinson and Tony Ahmed-Tamo. Can I just check before, just pause there for a sec to see if there's anyone who believes they registered to speak or who wants to address us who didn't hear their name? If so, unmute yourselves and let us know. Otherwise, I'll keep going. Doesn't look or sound that way, so I'm just checking that now because I won't give the opportunity for people who might be listening in to address us, because there is a process to register to speak and you don't really have the luxury of hearing everything and then having the last word. So what we'll do, and this is the normal practice of the panel, is hear from objectors where they exist first. I think we only have speakers against for the 3rd item on Oak Street, and then the applicant last, or representatives of the applicant last, who may also respond to issues raised. I can advise that panels had a briefing by council staff on all the items, and individually panel members have undertaken site visits as deemed necessary and having regard to COVID restrictions. That's in addition to a report from council staff which has been made publicly available. Hopefully you've read, because it's those reports and those recommendations we're considering today. I should mention there's been some late correspondence and information before the panel. That includes some potential changes and a staff memo for 10 Oak Street, a memo from council staff clarifying the modifications to windows at 12 Premier Street, a submission from the planner regarding the approved plans at 61 Lavender Street, and a memo from council staff regarding a draft set for 173 West Street. It would be appreciated if speakers can restrict themselves to 3 minutes each to speak, excluding any questions from the panel. There aren't a lot of speakers. I'll give a little bit of a latitude for that, but it would be appreciated if you could still be succinct and avoid repetition. And if it seems like you're talking for an extended period, then you may be asked to sum up. As mentioned, the panel may have questions at the end of your address. This meeting and the speakers, you may have gathered, is being voice recorded, and then that will be uploaded on council's website, usually by tomorrow, but within days of the meeting. Otherwise, there's to be no recording of this meeting, either verbally or video. As you're being recorded, you're reminded that you're responsible for your own comments. Please do not seek to personally criticise or defame any other people. It's not a town hall debate, it's not a courtroom, and so don't seek to discredit others in an attempt to win a perceived argument. That includes comments that may be made about council staff, other speakers, the panel, or people who aren't part of this meeting. At the end of hearing from people for each item, the meeting will close and the panel will make decisions, deliberate on each of the items, and then prepare minutes. Those minutes will include the decisions themselves and reasons, and those will also be published as soon as practicable, usually by tomorrow. So once they've finished speaking and exhausted any questions from the panel, there's no real practical need to hang around for the meeting. You're welcome to stay and listen if you like, but you won't be able to hear the decision of the item today. I'd ask that mobile phones be turned on silent and each speaker be heard in silence while addressing the panel, in courtesy and respect be observed through the meeting. As mentioned earlier, if you can keep on mute while other people are speaking, that would be great. Just remember to unmute yourself. We all catch out ourselves doing that, but if you're speaking and it's still on mute, we'll probably remind you. Hope that's all clear. Decisions of the panel of a majority vote. Chair has a casting vote if needed. Applications will either be approved, refused, or deferred. It's possible the panel may make a different decision than that recommended by staff. If a matter is deferred, it's also possible an application may be determined electronically or by council staff without another public meeting. So before starting and inviting Linda Hyler to speak to us, I'll ask to just check if there's anything council staff want to raise or clarify before we start. I don't believe there is. As I mentioned up front, there was some addenda report we received and some late correspondence.
I think it's Stuart Bryson for the first one. We're going to 12 Premier Street. Yep.
Oh, did I get it wrong?
Yes.
Thanks very much, Melissa. Yeah, sorry, there's a little bit of change in the order and some of the stuff we've got, so sorry about that. So 12 Premier Street, quite right, it's Stuart Bryson.
So I might just put everybody else in the waiting room, so that's all right.
Yeah, you whatever.
So.
I don't mind, you can keep them.
Oh, you want to just leave
them? No,
them?
I'd leave them.
Okay,
it's a public meeting, they can listen
sure.
if they want.
Just mute them all. Yeah, they're
Yeah, if you can stay on mute if it's not your item, but you're welcome to listen in or drop out however you want. Okay, so Stuart, are you there? I see you top right. Just got to unmute yourself and then fire away.
But what about 1?
Sorry?
Oak Street.
No, the order changed, Jen. It's a bit confusing, but 12 Premier was as distributed. So those minutes, wrong order.
Oh, sorry.
We're just talking amongst ourselves because there's a couple of different lists floating around. That's why I got confused. So the first item's 12 Premier Street and the applicant's representative is Stuart Bryson. I understand. Are you here to answer questions, Stuart, or you want to address us?
Yeah, just to here to answer. I don't have anything else to add other than my recommendation.
Okay, you're happy with the recommendation. Any questions from the panel? I don't have any.
Yep. No.
No.
No? Okay. Mr. Bryson, you get an early mark. Thank you. There's no questions from the panel of you. As mentioned.
Thanks very much. I might drop out.
Yeah, that's understood. Thank you. Second item.
Bye.
Thank you. Second item is 173 West Street. The applicant's representatives are Stephen Fale and Bruce Cuttins. Is there anyone else in that group? Are you both together? Looks like it.
I'll leave.
Yes, thanks. Caroline Pidcock is just leaving, won't take part in the deliberations or decision. Thanks, Ms. Pidcock. So who would like to speak or first?
Okay, Stephen Fale, architect from Woodhouse and Danks. We're the applicant. Really, I'm only sort of represented today here if anyone has any queries. The project has been lodged with council for quite some time. We've been through any number of meetings and iterations with the planning representatives of North Sydney Council. So we're more than happy for that we've got the recommendation for approval, and I'm here simply to answer any queries that you may have or respond to any objections if there are any. Thank you.
Great. Okay, is that the case for both of you? Thank you. That's helpful.
Yes, that's correct.
Okay, thank you. So questions of the panel, the 3 remaining panel members?
No, the only question is the...
Yeah, I've got a couple of
Yep.
questions. I'll just check.
Yep.
You got any questions?
No questions. Yep.
No.
I've got a question about the link housing. I guess just to outlay the thinking behind the question. So part of the justification of the shortfall of parking is that it'll be run by a social housing provider, which has a different car parking rate than otherwise. And it also has the benefit of, I think, generally better regulation and a requirement to make that housing available to low to medium income housing, which is a benefit to the wider municipality. So I guess I'm just asking, so I was a little bit unclear from reading the report about the commitment and the length of commitment to the provision by or management by link housing. You mentioned you're happy with the recommendation. One of those conditions in the recommendation is that it be managed by a social housing provider in perpetuity. So I'm just seeking your clarification of your intention and that condition.
Yeah, I don't think our client would be happy to have something placed on the approval as in perpetuity. Generally, in our sort of experience, these things have a termination period, and whether that's 5 years or 10 years, I think that's a more logical condition to apply. In perpetuity sort of creates basically a caveat on the site forever, which is, I would have thought, unmanageable in the context of a planning code.
Yeah. Okay. And what do you say?
We would seek the committee's approval to put a time constraint on it. I think that's a much more logical submission. We have done these boarding houses in the past, and they have had requirements for a number of years, whether that be 5 years or 10 years. I just think the client would, it's just a very strange condition to place on an approval.
I guess the counter argument is where you put that forward as part of the application and then justify the proposal, including on car parking and affordable housing, on the basis that it will be managed by that social housing provider, then I guess the logic is that that would be a condition.
The logic was that it's a condition, yes, but, you know, who knows whether link housing is going to be around for, you know, in perpetuity, or yeah, these things can change and morph into different things, and then suddenly we end up with a caveat on the client ends up with a caveat on the title. From a sort of legal point of view, I just think it's, and I'm not a legal representative, I'm an architect, but from a legal point of view, I think that's quite an onerous caveat on a title.
Right. And can I ask about the boarding house immediately adjoining this site? Is there any link in ownership or management? Is that, are you involved?
They are owned by the same person, but different companies and different partners, or directors of those companies. There is a connection, but it is a different entity.
Are they both proposed? Is that being managed by link housing at the moment, that adjoining one?
I understand that's right. Yeah, I don't know. We were only involved at the later stage of that 171. We didn't design it and get the DA approval.
Understand. Any follow-up questions from the panel? Or?
Well, it's just in relation to the same thing. On the one hand, prepared to take advantage of the provisions of the social housing, then not to have it in perpetuity. It just seems to be a little bit at odds.
Well,
Can the application be amended so that it fully complies?
no, it can't be amended because with the parking, which is the main parameter that is a problem there, is North Sydney Council didn't want us to put parking on the site simply because of the proximity to the corner and the profile in the street and such, and the narrowness of the sites and the streetscape basically. So they encourage us to not have compliant parking on there. Even they didn't want a layback for motorbike parking. We proposed layback for motorbike parking at one stage, and that was requested to be removed because they don't want laybacks in there. So we've got this dilemma where the council doesn't want the parking, and so the that would be very difficult to get it compliant, even though it's an ideal location for a boarding house as far as proximity and social housing is concerned.
Okay, thank you. Well, I think a 10-year minimum is the minimum that we could expect, and we'll have to consider.
Have to think about the other way is either have it in perpetuity, and then depending on how it's managed, you could apply to modify that and suggest an alternative arrangement.
Yeah, I just on behalf of the client, I'm sort of very reluctant to seek anything. 10 years is fine. I can see that as being a logical bonded period, as it were, but kind of in perpetuity, just really, I just think that might create a legal problem.
I was just seeking clarification originally because I thought you were happy with the recommendation. That was one of the conditions.
Yeah, one of the conditions is 19, that the boarding house would be operated by a registered social housing provider, such as Link. So, whether it's Link or another social provider.
Absolutely. Yep. Yeah, no, we're right on agreement with that. Yeah.
I think it was a little bit unclear because I had sort of taken from your application that it wasn't a proposal in perpetuity. That was a condition. So I was just clarifying that you were happy with the conditions. It doesn't sound like you are. So I was just seeking clarification on that.
We're happy with.
Understand your position.
Yeah. Okay. We're happy with Link because we've already connected with them to manage it. Yeah.
Understand. Any other questions from the panel?
No, thank you.
No.
No. Okay. Before we call the next speakers, we might just get Ms. Pidcock back in for the third item.
Yeah, thanks.
Thanks for that. Thanks for that.
Thank you.
You're welcome to stay, though we understand if you choose to leave, Stephen and Bruce.
Okay.
Thank you.
Won't be affected. Okay, thanks. Caroline Pidcock's rejoined us for the third item, which is 10 Oak Street. We might hear from Linda Heiler first, and then, as I mentioned earlier, the applicant's representatives, in my understanding, is Simon Rosewell, Louisa Alessi, and Cameron Allen Gillies. So is Linda there?
Yes, I'm here.
Linda, you're ready to talk to us?
Yes, I am. Thank you. Good afternoon. Thank you, panel members and chair, staff, and members of the community. I'm Linda Heiler. I'm the owner of the Western Heritage listed dwelling at number 8 Oak Street in North Sydney. As indicated in the assessment report, my cottage and the subject cottage are part of a row of original semi-detached cottages. These contribute significantly to the street character and are important reflections of local history, we believe. I appreciate the desire of the neighbour to improve their property. However, this should be in a way which sympathises with heritage integrity and which does not unreasonably impose on neighbours. I'm in a position where I have a raised objection as this proposal introduces a large 2-storey rear addition which will be visible from the street, being higher than the original roof profile. This will interrupt the unity of the heritage row. We agree that the addition is overscaled and does not carefully respond to the context or the planning controls. The high rear wing would considerably impact on the visual amenity, feeling of space, privacy, light and sunlight available to my small and valued rear courtyard. This is the only area of private open space for the house. This space is currently private, is light and receives dappled sunlight. The sun and light to this area is already constrained, and further imposition by a non-compliant form is not considered reasonable. There are plantings at the boundary which also rely on light and sun. We have raised these issues and provided photographs within our 2 planning submissions. We agree that a room in the roof style would be appropriate and would better protect neighbours, local heritage and the streetscape. Thank you, staff and panel members, for considering our points of view.
Thanks, Ms. Hyler, for being brief.
Yeah, I tried to keep it brief because I know everybody's busy.
Appreciate that. Questions from panel members?
No, thank you.
No.
Ms. Hyler? No? No, none from me either. Okay, so next we have the applicant's representatives, Mr. Rosewell, Ms. Alessi and Mr. Gillies. Not sure who'd like to go first out of that group.
Mr. Rosewell then?
I think he's having trouble connecting to audio.
Yeah.
It's Mr. Rosewell
It's been
trying
coming
to
in and out.
Maybe it's Alessi.
connecting.
Try it.
Maybe Louisa, I think.
Yep, sure.
If that's
Good
okay with
afternoon.
you.
Thank you for your time. We were actually just mainly wanting to maybe address any concerns or questions that the panel might have. But maybe I can also just touch on some of the things that Linda mentioned. I think, as you're aware, the actual design has been amended a number of times, and each time in accordance to the advice we were given to council. With regards to that 2-storey addition, as you know, we've now pulled it back. We've separated it from the existing primary wing of the cottages, primarily so that, you know, we can actually keep the integrity and roof form, and just with regards to that, and also the point about possibly using the roof. This is why we did not choose to use the roof space. We thought that would actually have more of an impact on the integrity of the group and of the building, and therefore the group. Definitely would alter the primary, what I would consider the primary wing and the primary form of the building. So we tried to push it back, and we've also reduced the size of the wing and this increased setbacks from the western boundary. As you can appreciate, we've got a pretty high blank brick wall at the back of our building. And again, whilst the roof of the proposed addition does exceed the existing ridge of the front wing, we think that it actually will now, it falls part of that backdrop. And we've also, with the setbacks and that pavilion style, pulling it back from the main wings of the buildings. If you look at the street views, you can actually see that it's not a highly visible element in the streetscape, and the primary wings of both numbers 8 and 10 and the neighbouring buildings still are highly legible, highly visible, and obviously will be in the foreground and contribute to that streetscape. I'm not sure if Simon can address any other amenity issues, but from a heritage point of view, I think it's much improved. And as I said, we've very much worked in consultation with council, with our team, and just tried to address all the concerns that have been raised.
Mr. Rosewell, have you got your audio sorted? Do you want to add anything?
Thank you. Yes. Can you hear me?
Yes.
Great. Yeah, no, I think, as Louisa had said, we've worked council all the way through, from having the pre-DA at the outset, where we went in with what I call more of an adaptive heritage proposal with dormers to activate the street. But, you know, we understood council's preference was to retain the advice at the time was that we could have a connecting element as long as it wasn't visible from the street. So hence the stairs were originally in the back of the the original 4 rooms. And I should reiterate that the 4 rooms have under new doors, new architraves, new trims, new ceilings, new fire. The merit is, as Louisa says, is very much the grouping and the resultant streetscape that comes with that. And I guess we followed council's I guess a strong recommendation to have a look at 41 Edwards with the pavilion style, which I guess we're just refining. I guess, yeah, we believe we've satisfied each. This is the 4th. We've satisfied the requirements, and then the requirements, there's additional requirements. So it's been a long process, but we've been, as I say, yeah, very willing to collaborate and work. At the same time, I guess we can't lose sight of the fact that this is that a heritage item still is someone's dwelling, where we've trimmed it and trimmed it and trimmed it and trimmed it, and it's on the cusp of.
So, Mr. Rosewell, you've cut in and out a bit, and I'm a little bit worried that we might have missed some of the key points. Maybe succinctly, and sorry if I cut in before you'd finished, but maybe just to this point, if you could just reiterate fairly succinctly what the key points are to here that you've made. I've heard that you've made a number of changes. You thought you were responding to all the issues that were raised, kept the height down and did it to the rear, and have been willing to accommodate changes. But maybe you could just succinctly recap on the points you've made to date to make sure we haven't missed any of the key points.
Key points are, yeah, with 4th version, working with council.
Yep.
We've now very much at pavilion style, very much like what we were referenced originally, 41 Edward Street, where we've now got the new work separated from the original. The element ours is now below the eaves line, as Louisa recommended, is the preferred way to deal with a separation. Definitely can't see the link from the street. With first floor's been pulled in 1.5 metres, as was in any case. And I guess the planning, the rest of the planning speaks for itself. The landscape, we believe, is actually compliant, contrary to the recent report. We believe it's stood from the outset at the pre-DA. If we adopted this form, where we believe there's a marginal variation is the site coverage, but by pulling all the proposal or proposed works out of the original 4 rooms, there was a consequential.
Could you just move a little bit closer to the microphone, Mr. Rosewell? Just stay very close to the microphone. We're having a lot of trouble with you cutting in and out.
I think about every 6 to 8 seconds you cut out, and it's very difficult to follow. So I'm not sure what's causing that. I think we're getting the gist of what you're saying, but we're not sure about the import of some of the words we're missing. I don't know if it's proximity or connection. I don't know. But anyway, is there anything you want to add?
No, we're happy to take any questions.
And Mr. Gillies, do you want to add anything?
Submission, we would trust would be acceptable, and we very much hope so at this point.
We did receive the late correspondence from yourself. We also got a brief addendum report from the council. It'll be on the website as well about that. I'd had Mr. Gillies, I'm only checking with Mr. Gillies, so I did have him down as a registered speaker. I'm just double checking whether you want to speak or whether you're here to answer questions, Mr. Gillies.
I'm happy to just summarise, I guess, our situation very quickly. Our original motivation was to improve the amenity and livability of the property, and most particularly in context of the street and the heritage values thereof. The the exterior of the properties, you know, the attraction, I guess. The interior of the property is has little or no heritage or original items, and is in actually fairly poor condition. Various builds and modifications over the years have been done to a particularly poor level. So that was our, I guess, overall intent. Surrounded by large buildings, and particularly the large apartment at the back, it's been a challenge to come up with something with fair regard to the neighbours, to the neighbourhood, and whilst you know, I guess providing and renovating to a livable standard. My wife and I are both fairly tall people. So yeah, you can hardly swing a cat in there at the moment, and it's not a particularly attractive living environment. So, like as Simon and Louisa said, we've gone through various iterations with council. We requested, sought, and had a pre-DA meeting. We're given guidance and advice. Without being critical, it seems like the goalpost may have moved once or twice through the process. But yes, look, we regard your assessment process and hope for a favourable outcome. Thank you.
Thank you. Questions from the panel? I guess I've got one. I mean, from the council report and the briefing from council staff, it's pretty clear that the key issue for a heritage item in mediating both the heritage item and the large buildings around it is the scale and relationship and the overscaling of the addition relative to the retained dwelling. And, you know, the DCP diagrams are fairly clear in terms of trying to have a one-storey separation in the pavilion form with the second storey in the roof, both to separate the new works from the old, but also to bring down the scale of the rear addition by utilising roof space to not dominate the heritage item. So if that's the concern, given the DCP, I'm not overly surprised about the concern with the scale of the proposal and the site planning that you put forward. So what do you say about the proposition that I'm reading, that really, if you're to do it, which is that not that you shouldn't do any addition in the rear yard, and not that there's no possibility of even accommodating some accommodation above ground floor, but there should be some meaningful separation through a one-storey lightweight pavilion, and then a two-storey form that's really one storey and an attic form that is more diminutive in scale. What do you say to that?
Well, you know, I'm finding it hard to visualise exactly what you're presenting, and I'd probably refer better to Simon's architectural judgment on that.
Right.
Simon?
Simon, do you know what I'm getting at? I'm just visualising what's written.
This is a very modest sized dwelling that's been presented. It's actually very commensurate with the one recently approved in 41 Edward Street. Again, with 1.5 setback, rear boundaries one side.
Right, okay.
Restrictive environment with a 6-storey blank wall hard against the rear boundary. There's a 20-storey tower, 2 doors adjacent looking into the courtyard. There needs to be a degree of amenity where the west, so you actually see some blue sky. Otherwise you're just enclosed completely. But in terms of the scale, we think it's commensurate. The 1.5 setback has now made it virtually impossible to see from the street in public domain. So we believe it's, entirely appropriate. Yes, it's a 2.6 first floor. That allows 2.4 minimum plus 200 for air conditioning. It could be reduced.
Sorry, Simon, cut out there.
The DCP requests 2.7. So
sorry, you cut out.
I was saying we've kept the heights very modest. 5 degrees is the minimum pitch for the ceiling's 2.4 plus 200 for air conditioning, so 2.6. It's below the DCP. The floor plate is as small as it can be to provide plumbing and structurally supply that. We've proposed a 2.7 only, not 3 metres, as per the DCP ceiling height in the rear. So
Okay.
Okay,
Mr. Rose, we might keep your answers a bit shorter if we can, because we're losing 20% of it. And we might ask Louisa also to jump in, because it's just really hard to hear you and we're not hearing everything, so it's not helping.
Yeah, basically we believe that's as minimum as we can go. We've got a little bit of leeway to go, possibly reduce the height a little, but as the owner says, they're both tall people, and we just wanted to give them as much space and livability in the house as possible. The height, yeah, as I said, the height could be reduced a little, but from amenity point of view, and I think you just have to bear in mind the context. And I think when we've got that, quite high, solid blank brick wall directly behind the form and the proposed amenity of our addition is basically to actually improve that rear courtyard space and give the actual property a little bit more amenity as well, and not just have face a blank brick wall. At least this way we've got planter boxes and so forth. So we tried to soften any potential sort of impact of that upper story as well. Yeah, and I think, as I said before, I think just bringing that simple little single story link and just opening up, that might actually also improve the readability of any potential sort of bulk and scale of that rear addition.
Understand. Any questions, Caroline Pidcock?
I'm just interested in your you talked about context, and I'm just thinking that your neighbour, the context that she's sort of seeing, that the little space that is actually there is about to be filled and she's about to be totally overlooked at a very close proximity. What do you think about that? I mean, I understand the desire to sort of have more space, but you kind of bought into an area where no one else has got a 2-story rear addition, and that is sort of what's working well for everyone there. And I'm just intrigued as to how your rights, your perceived rights, are sort of seen to be more important than everyone else's rights.
Well, might I just add that the property next door, in fact, does have a second story.
Where,
So,
in the rear garden?
Should I comment on that one? Is that possible?
sure.
No, we might just restrict the questions. I know there's an adjoining approval that's smaller in scale, I think, and what council's more pushing towards. But no, it's not really an open discussion. Then it's not that we don't want to hear from you. We'll just exhaust the questions from the panel, and then if there's any burning procedural questions you want to add or points you want to make, we'll come to you. But I don't want to have an open discussion around table. But sorry, Caroline.
No, yeah.
But Mr. Gillies, you're just making the point there's 2 stories in the rear yard elsewhere.
Throughout the street, I mean, I would guesstimate maybe 6 to 7 properties have various forms. There's no consistency to the scale or format of those designs, but
and also, if you actually look at the solid to void, I'm not sure. In my report, I think there might be aerial photographs and so forth. Whilst some of the other buildings don't have 2-story rear rings, that actually cover a larger proportion of the rear yard. So I think in this particular instance, it sort of made sense to go up, because we are very restricted and we've got a very relatively small rear yard, and we wanted to keep a relatively small rear yard as well. We wanted to keep some private open space. So it was a logical sort of thing to go up, particularly, as I said, we've got that, in that context. And I think even number 8, I understand the rear wing has quite a bit larger footprint as well. So that was part of the logic behind that as well, just to keep that a bit of open private courtyard space as well.
Okay, we'll finish any questions from the applicant. We'll give you one last chance at the end, because I know there's comments made, but not now, Ms. Hyler.
Yep.
Questions of the applicant?
Yes, Louisa. So with the revised amendment that you've done, is the proposed site coverage reduced from 67.6?
I'm not sure of all the sums, but basically we have set back considerably from that western. Now the kink section is, I understand, 1,500 now set back at both ground and first floor level.
Because the major non-compliances were the maximum site coverage was 60% and you're 7.6 over, and the landscaped area is required to be 20%, and you've only got 7.5, and you've only got that little slither of courtyard at the back. So I'm just interested to see if that's been, with the amendment that you've done of the 1500 setback, if those figures are better.
I'm not sure. I have to check with Simon.
If I could jump in, the site
Make it quick
coverage,
because we'll lose you.
the site coverage was always given as a dispensation by not touching the heritage component of the house.
Just to answer this question briefly, do you comply with the site area and landscaped area in your revised proposal? And if not, what's the improvement? Just figures.
Sorry, I didn't catch that.
The question is, in your revised latest proposal, you've got non-compliance currently with site area and landscaped area. Does the most recent revised proposal comply with the site area and landscaped area? And if not, what is the improvement in percentage?
Yep.
The landscape area is actually compliant. The landscape area, or the site coverage, we haven't changed.
Right. Okay, so there's a difference of view about the landscape area. The site
Setbacks up on the
coverage
first
hasn't changed
floor.
with the last. Okay, thank you. Other questions?
If perhaps Louisa could
Louisa, there was, oh, sorry.
just
Go on.
comment on what you heard about the concerns of the neighbouring property at number 8.
Okay, I thought I already had, but that's okay. So I understand the concern one was streetscape character and the impact of the integrity of the group. Again, you know, the pavilion style is an accepted approach that actually separates the old from the new, but also we did that. We have retained the front primary portion of the existing cottages. And obviously they will continue to be highly visible when looking along the street, not just this single house, but the adjoined house and the whole group. The higher roof profile, again, we have set it back, and if you look at the street views, it actually is not a dominant element, and I think it will actually, if it is at all visible, it will sort of form part of that higher backdrop that exists.
Okay, my question goes more to the amenity of the open space courtyard of the adjoining neighbour at number 8.
Well, unfortunately, I haven't really looked at that, but I understand the concern.
Jump in there.
You're
on mute.
Oh, sorry, I actually missed part of the question, dropped out.
I'd just like you to respond to the neighbour's concern about the amenity of the courtyard at number 8.
Yeah, we've done extensive shadowing analysis where the context itself has ruined the amenity to the extent that we had discussions that there should be a specific DCP for all the owners to be able to develop their houses in the most appropriate way, which is what we believe is how we're adopting it. So I think we're setting ideally a precedent for everyone to be able.
Thanks.
You've got 20-storey towers to your east. We've got 6-storey towers to our north. I think it's a solution not just for us, but it's a solution for everyone, which is the right solution for this context.
No.
Any more questions from the panel?
No, thank you.
Okay, look, Ms. Hyler, I don't like to, it's not a round table, but there were some comments made of in relation to your adjoining property that you wanted to jump in. Factually, as opposed, not giving you the floor to make or reiterate points, is there anything you want to say that you believe is correct or incorrect from the submissions you've heard?
Thank you, panel, for allowing me to ask a question. I think in the beginning you said that new plans had been submitted. Is that correct, or amended plans?
There have been some revisions that have come in that you wouldn't have seen because they're yet to be uploaded. So no, there's been some refinements. Council staff's view, and I don't want to put words in their mouth, were they've been received late and they don't really have time to assess them properly, so they don't want to assess them as the proposal. There is a mechanism for an applicant, if they wish to do a review of determination through, which would go to a new panel. So yeah, there are some refinements that have been made, but the summary of the council's position on that in the very short time they've had to look at it is it doesn't address some of their fundamental concerns. But
So
yeah,
would I have the opportunity to have a look at those amended plans and
there'll be a
review them?
determination made, and I'm told they're already on the website now. They've only just been received, so you could have a look at them. But
Okay. I just hadn't. I checked the website, but I didn't see anything last night. So
yeah,
that's
the decision of the panel will be based on the plans that are before us, not those, but they're publicly available.
Okay, and just one other comment. We don't have a second story in the back of our residence. We've used the roof line to have a bedroom upstairs, but that's within the current roof line.
Okay, thank you. Any last questions from the panel?
No,
okay, thanks everyone. That was helpful. Mr. Rosewell, I suggest someone look at your computer. It's not working well today. Hopefully it'll get better for the future, but we certainly got the gist of the points you were making. So thank you. We'll move on to the next item.
Thank you very much.
Thank you.
Thank you.
Bye-bye.
Next item is 49 Carter Street, Camero, but we don't have any registered speakers for that. I'll just double check there's no one in the Zoom world or whatever world we're in, the Teams world, that wants to address us on this item. No? Is there any questions of the panel of council staff on this before we move on to the last item?
No.
No? Okay. In that case, for the last item, and thanks for your patience, we have the applicant's representatives, which are Sandra Robinson and Tony Amadamo. Sorry if I've mispronounced your surname, Tony.
Tony's just here to observe, Chair.
Thank you. Ms. Robinson, would you like to address us?
Thank you, Chair and panel, council staff. We're very happy with the report and recommendation. We have, however, requested a couple of corrections to the revision numbers and condition A1. I think that was just because there were some amended drawings submitted to deal with some waste issues that were raised by the community. And I think the PTW perhaps had a couple of revision errors on their drawings. So other than that, we're very happy with the report.
We've got the correspondence, and if it's approved, we'd seek advice on council staff. And if that's aligned with the information that's lodged, that sounds like a procedural change. Any questions from the panel? Look, I've got one, Ms. Robinson, but can I give you a long sort of explanation of it? Because it's really, it's really one of planning theory and law as opposed to the merits, because I think, you know, the changes in this application, I don't think there's any doubt it's substantially the same as the last development in terms of the quantity. There's, you know, a couple of less units, there's some more commercial space, I know, and the interface of the public domain isn't markedly different. But with the changes to the Act that happened when they brought in 1As and 2s, there's that, you know, the couple of the two changes of specifically requiring to get rid of any ambiguity that did exist, that the substantially the same test should be not against the current approval, but against the original approval, and the 1As versus 2s. I think you're aware of, and you've addressed in the SEE, so that whole quantitative and qualitative assessment that needs to be made has to be made against the original approval, and you're aware of that, and you've addressed that in the SEE, and that's addressed in the report as well. But I guess I'm just having a little bit of difficulty with it because of the numbers. You know, if you look at the number of dwellings, which goes from 92 to whatever it is now, 128 or 130 in that order, it's a fairly significant change in the number of dwellings. And there's been changes to the commercial tenancies and quantum, and the relative car parking as opposed to, you know, 2 units is not proportionally changed. So I guess in my mind, there was a bit of a concern about the quantitative part of that assessment. You know, comparing back to the original, it doesn't arise from this mod, and it's not a criticism. It's just the, you know, the circumstance of the Act changes and what we're required to satisfy ourselves about. So then that quality, and sorry, I'm getting to the question in a sec. I'm just sort of giving it. The panel's already heard this, and so has the staff, because we had a briefing on it. So sorry, especially to them. But the qualitative thing in my mind has that, you know, what did the building originally look like when it was approved? What's it look like now? And what was the public domain interface? And I've got to say, having looked at the original elevation and the layout, I'm a little bit concerned in that area as well. So I guess, you know, that's just the background to the question of, can you just help satisfy me that this thing is substantially the same when you compare it back to the, you know, pre-14 modifications that have been done back to the original DA? I know it's in your SEE, but I just want you to elaborate a little.
Thank you, Chair, and it's a very good question. As you said, there have been many modifications for this development, and the current owner has done about 4 or 5 of them. The previous owner did the earlier mods. Not that that's relevant, but just by way of background. In the SEE, we have compared the development both to the modification to the original consent and the most recent, or what we call the current consent. In terms of numbers, the modification actually brings the development closer to the current consent. If you look at the non-residential area, the original consent had 1,370. The current consent has 702, but the mod takes it up to 877. So in actual fact, the difference in the increase in GFA makes us more similar to the original consent. So that.
But I don't think there's any. Sorry to cut in, Sandra, but I don't think there's any. Like, I'd concede straight away that compared to the previous approval, this is both substantially the same and also closer to the original approval. I'd concede that, but I'm still the real struggle is, I guess, you know, not a practical one, but a sort of, you know, legalistic one, which is the original DA versus where we are.
The simple answer is the momentous change happened in 2010. So the significant change to the number of units and the non-residential was approved in 2010. Now, at that time, the test was the original consent. That test for the original consent arose out of, if Mr. Beattie's in the room, he will know this, out of a court case in Milson's Point called Michael Stanley v North Sydney. And after that, and I can't remember the year, it's a very long time ago, more than 20 years ago, after that, the test became back to the original consent, not the most recent consent. So this development has had that burden for all of the modifications. In 2010, the Consent Authority, then Council, accepted that significant change, which to the number of apartments and the non-residential, still rendered the development substantially the same as the original consent. So that momentous change happened more than 10 years ago.
That test has been relevant all the way along and been passed previously, and this brings it closer. That's the essence of your argument.
Yes.
Right, okay. Other questions?
No, thank you. No.
No? Okay. Any things you want to add before we close it off, Ms. Robinson, this item?
No, just thank you for your time.
Okay. Thank you. That being the case, we'll declare the meeting closed at 2:55. As I mentioned, we'll deliberate till we come to majority decisions on all these items and publish it as soon as we can, hopefully tomorrow, but within days.
Thank you.
Thank you.